Welcome to the Public Accounts Committee on Thursday the 4th of June 2026. Today is the second instalment of our Compensation Week, in which we are examining the government's administration of compensation schemes. On Monday, we heard incredibly powerful testimony from expert witnesses on 4 of the government's compensation schemes. I'm sure you've watched our session and, like us, found some of what they had to say very difficult to hear. What some of these people who have used these schemes have gone through is unacceptable. And I would like us to bear in mind those people today when we're talking about what will seem colder and more distant concerns of value for money, scheme designs and the working of inner government. But of course this is all about people who have suffered. So today we are joined by very senior officials from a variety of government departments and arm's length bodies, each of which have been responsible for administering at least one of the 7 compensation schemes that the ANAO examined as part of their report on this subject. We'll be looking to challenge the departments about their administration of these schemes and to examine the reasons why the experience of making a claim has varied substantially for affected individuals seeking fair redress from the schemes. We will also be exploring whether the schemes are doing enough to ensure potential claimants apply and their needs are met during the claims process, and examining how government plans to apply lessons learnt from the schemes to future schemes across government. I'd also like to take this opportunity to thank every individual who has engaged with the committee via our survey. It's been incredibly valuable for us to hear from people about their lived experiences of applying for compensation schemes. So we are extremely grateful to all of those who took the time to complete this survey. So without any further ado, I think, Kat, you have... Good morning, everybody. Let's let everybody introduce themselves, starting with you, Kat Little, please. Just who you are and how long you've been in post would be helpful.
Thank you very much, Sir Geoffrey, and good morning to the committee. My name's Kat Little. I'm the Permanent Secretary at the Cabinet Office, and I'm also the Chief Operating Officer for the Civil Service. I have a couple of hats here today. Firstly, being responsible for the overall policy for inquiries response, for the Public Accountability Bill and the duty of candour, and also coordinating cross-cutting work across government. But I'm also the Permanent Secretary for the department that sponsors the Infected Blood Compensation Authority.
Thank you very much. Jeremy, would you like to introduce yourself?
I'm Jeremy Pocklington. I'm the Permanent Secretary at the Ministry of Defence, and I've been here for 6 months.
Gareth.
Gareth Davies, I'm Permanent Secretary of the Home Office. I've been here for 6 weeks. Prior to that, I was in the Department for Business and Trade, where I was Permanent Secretary and responsible for the Post Office redress schemes with Carl.
So Carl, would you like to introduce yourself, please?
Thank you very much. I'm Carl Cresswell. I'm Director for Post Office Policy. I have been working on this area since 2019, when my role was established following the Mr Justice Fraser judgment.
Thank you. And finally, David, please.
Thank you. Good morning. I'm David Foley. I'm the Chief Executive of the Infected Blood Compensation Authority.
Thank you very much. So, Kat, I think you've been warned at the top of the session about promises to set up future schemes. So I'm going to turn to Sarah Green, who asked the Prime Minister a question yesterday on this subject.
Thank you, Chair. I should declare an interest at the top of the session. I chair the cross-party group that is campaigning for redress for victims of surgical mesh and sodium valproate, and it's important I put that on the record. The Hughes report was commissioned by the Department of Health in the previous Parliament. They asked the Patient Safety Commissioner to look at how to implement a redress scheme. The case for a redress scheme had already been made in the Cumberledge Review, so this wasn't this was a how to implement, not a should we implement. But it's been sitting on a shelf for 2.5 years, and successive health ministers have indicated that it's the complexity of cross-government working that is delaying the implementation of that report. So I'd like to ask the Permanent Secretary, if I may, what is the delay, why is it taking so long, and what is happening at the centre to unblock those delays and introduce a timetable for when this will be actually implemented?
Well, firstly, thank you for letting me know that you were going to ask this question. I got in touch with the Department of Health last night to try and get to the bottom of some of the questions that you asked yesterday and today. I think the first thing to say is these are really important issues, as you know better than anybody. And what I understand from the Department of Health is they've been taking the time to work across government and to make sure that they get the right collaborative input on the policy design from various parts of the public sector. My understanding is that Minister Ahmed, who was the previous minister, recently met with the Patient Safety Commissioner and talked through the detail, but I'm not privy to all of the detail that was disclosed in that discussion. But with your permission, Chair, I would be very keen to meet with the member and to just better understand some of your concerns to see if there's anything we can do on a cross-cutting basis to help.
I'd really like to take you up on that. Thank you very much. Thank you, Chair.
Well done, Sarah. Thank you very much. So I think I'm going to come to the first sort of substantive question, and sorry with your voice, Gareth, but I need to come to you because it is on one or two questions on the Horizon shortfall or the Horizon schemes. I think the first question is, we know from the NAO report that at November 2022, 2,417 people had applied to the Post Office for these schemes, which was way in excess of what you expected, to the extent that you had to pause the scheme because there wasn't enough money. So the first question is, why was it such a surprise that so many people wanted to apply for these schemes? I would have thought it would be possible to ask Post Office to press the Horizon button and hope that they came up with the correct answer. And then, once we've established why it was a surprise or it wasn't, why did you have to pause the scheme because you didn't have enough money? Surely government, in setting up any one of these schemes, and I hope it will never happen to any of the schemes that Sarah is talking about, once you've decided governments to set up a scheme, surely it should decide that there's enough money to fund that scheme.
Yeah, thank you, Chair. I mean, on the first point around the scope and scale of the Post Office schemes, I think the thing that certainly surprised me coming into the role in 2023 was the lack of grip on the data in the Post Office. So the actual underlying, partly this reflects the problems with the underlying Horizon scheme, the IT platform, and so their ability to produce accurate estimates of the scale of the losses was consistently underwhelming. So we had a problem with actually identifying and getting our hands around exact numbers over that time. And certainly, as you see, if you look at the process over the subsequent 3 years, the number of people who applied to HSS increased significantly. I think Carl will have the numbers, but they'll increase, I think, almost tenfold. The broader question, which I was concerned about as accounting officer responsible for the collection of Post Office schemes, was the fact that originally the budgeting for those schemes was through DEL, so through our controlled totals. I worked with Treasury to shift that into AMI to make sure that there were no artificial constraints on the amount we could pay out. Throughout that time, we always flexed our budgets to make sure we could pay the right amounts. But I think by having it in AMI, it was partly for two reasons. One, just in terms of simplifying the accounts and the reconciliations, but also to provide more assurance to people who had applied to the scheme that there was no sort of false constraints on the amount to be paid.
Yeah, may I just add a little bit of detail because I think it's of wider relevance. The original Horizon Shortfall Scheme had a deadline. It was set up with a deadline, and 2,417 people applied for that deadline. So there was funding available at that point. What the Post Office discovered was that people continued to apply, and we've had a further figure of 11,669 on top of that. The funding issue was how to fund the later applications beyond the original deadline, and that was where, as you may have seen through Sir Wyn Williams' inquiry, we had to work with Treasury to secure the extra funding for the Post Office. But the fundamental point is that the Post Office thought there were going to be 300 people, and I think that reflects a broader misunderstanding of the depth and horror of the Horizon scandal, and it's only been over a period of months and years that we've realised quite how many people were affected.
So I suppose the next question is, and I mean, if you either, and I'm going to let either of you answer this question, but it's on Horizon. The two things that really came out powerfully from me on Monday's hearing was one, trust, and second, co-design. And if you've done both of those things, it does seem to me that and of course this is with hindsight, but we need to learn the lessons from what you two went through to try and work out what we need to do better in future. That actually having the sponsoring department, let alone the sponsoring organisation administering the schemes, was a very poor way to establish trust. And I think if you'd co-designed it better, you'd have got a better idea of how many people were likely to make claims. So very briefly, either of you or both of you, what should we be learning from these schemes that we shouldn't do in the future?
Yeah, so a couple of reflections from my time responsible before I pass to Carl. Firstly, I mean, these schemes, as I think the report set out, are trying to do three things. We're trying to provide accurate redress for the individuals, so there's something about being specific. Do it with a sense of speed and pace, given the injustice they've faced, but also provide a level of voice and essentially restorative justice around this. So I think those are the three things we're constantly, when we're designing the schemes, we're trying to balance. There are a couple of things I think where, with hindsight, we would have done things differently. Firstly, there was a series of initial decisions to resolve specific problems. So that's what, rather than standing back and understanding the full scale of the challenge. I think, as Carl just touched on, the Post Office itself didn't realise the scale of the challenge, and this has come out of the independent report. And so what we now have is, I think, 4, potentially 5 schemes, depending on how you describe it, all with slightly different rules, ways of working, and we've learnt our way along. Rolling back time, you would have wanted one scheme that would have been able to tackle all of these issues at the same time. So I think that's sort of the first point. I think this point around co-design is totally right, and I think being explicit around how we get the balance right between accuracy, speed, and voice is at the heart of some of these things. And I think making those decisions explicit rather than implicit would be my reflection. Final point before I hand to Carl. I've reflected on the report and on the evidence about, should the organisation at fault be the one to do the redress? And I think this is a very delicate balance. On the one hand, I can understand completely why there's deep scepticism and lack of trust, because these organisations are not trustworthy. So therefore, you'd want an independent organisation to be able to deliver them. But on the other hand, it's that the organisation that has done wrong, that has catastrophically let down these people, stuff is just should be responsible for. I mean, I hesitate to say righting a wrong, because I don't think you can right the wrong, but you can provide the redress, and they should be responsible rather than just outsourcing it to another organisation. I think it's a very delicate balance, and I can reflect more on the Windrush experience in the Home Office later. But
Thank you. I do agree with Gareth. I think it was a mistake to have the Post Office deliver the Horizon Shortfall Scheme. There were reasons for that at the time. It was a commitment that was agreed with Sir Alan Bates's GLO group in December 19 when a settlement was reached. So at that point, it looked like it was going to be a viable delivery organisation to the claimants. But I think over time it became clear that even though there are independent panel members making the final decisions, the claimants have low levels of trust in the Post Office. So it's, I think in retrospect, a mistake to have the Post Office do that.
Thank you very much, Carl. Rupert Lowe, please.
Yes, I've studied this Post Office situation in quite some depth. Indeed, I've written articles about it. I couldn't disagree with both of you more. I think this is a massive state fraud. The knowledge of the flaw within the software, in the Fujitsu written software, was known for a long time, and it was covered up. And as you know, the Post Office has a government covenant, an ability to actually prosecute people. So they were going round prosecuting people on the basis of a fraud, which they knew about. So at the end of the day, this is another example, in my opinion, of the state making a series of bad and fraudulent decisions and then basically not dealing with the fallout from it, either in a timely way or an efficient way. And I think the public is becoming increasingly irritated by the fact that the government appears to be incapable of, first of all, making good decisions, and secondly, cleaning up the mess that it creates, which it gives itself the job of doing. So I'm sorry, I mean, you can give as much verbal baby food waffle as you want, but the fact is we need to get this right.
I think we've got the point, absolutely. Gareth and Carl, do you want to
May I come back in on that one? I mean, I think we should be judged on our results and how much has been paid out at this point. If the committee is looking at where we have got to with the different schemes, we have paid out over 1.5 billion to 12,600 claimants. There are definitely lessons to learn, and we're here to talk about that today, about what we've done, and we've tried to apply them in later schemes. But fundamentally, I think we are in a place where 80% of the claimants have had the money, and we should be through a lot of them by the end of this calendar year. On your broader point around who exactly did what, I'm sure there are failings that need to be revealed through the Horizon inquiry. I'm expecting that to report later this year. Sir Wyn Williams has already said in his first report last July that the Post Office executives should have or could have known what was going on in the organisation. So to that extent, I agree with the thrust of what you are saying, but I think we have a stronger delivery record than you're giving us credit for.
Fine, but there are a lot of people who've died without getting any compensation at all, as you know, because this has taken so long to be dealt with.
Yes, yeah, that is a matter of deep regret, as I say.
So I have one fundamental question to ask, and I don't mind which of you ask. Maybe this is a question for you, Kat, I don't know, but it may be a question for our everybody who's involved with Post Office. I think the public out there will want to know why it is that we've still not got a single penny in compensation from Fujitsu. Why is it that the British taxpayer always has to bear the can for the company's mistakes? If they've made a mistake, they should surely be the ones that should compensate. The same thing is probably true of the American blood companies and the infected blood scandal. And there may well be other liabilities in the other schemes. So one of you, I would be grateful to know what the government is doing about this, because it does seem to me that the British taxpayer should not be bearing all the burden on these schemes.
Yes, I definitely agree with you in relation to Fujitsu. I will leave the infected blood question to others. My ministers agree with you as well, and they have been having conversations with Fujitsu about it, and we are in negotiation and discussion with Fujitsu about what a reasonable settlement would look like. We, at this point, are awaiting the outcome for the Horizon inquiry, because I think that will help us nail Fujitsu down for a specific number. They have not at this point offered a specific number, but they have made a commitment and they've recognised their moral obligation to contribute towards the costs of the scandal, and we plan to hold them to that. But at this point, I don't have a number to give to you.
So there is an intention that Fujitsu should compensate. Can we be assured that the government will push this hard and, if necessary, take it to court?
I am sure you can have that reassurance from me, yes. And if you would like a private briefing about our negotiations with Fujitsu at a later point, I'd be very happy with my colleagues to do that.
We might well take you up on that, Carl. Thank you very much. Does anybody want to talk about infected blood? Oh, Kat, I see you want to come in.
Could I just add to the Fujitsu side of the question? David should answer on infected blood. Fujitsu is a strategic supplier to government, and I would also just add to Carl's offer, I'd be very happy to come and talk to you about the wider commercial arrangements that we have put in place.
David, do you have anything to add on affected blood? Because I think this is one of the really awful ones. We heard some of the terrible testimony of children dying one thing and another on Monday. Really, really terrible there. I think people will be looking to know why we're not taking this up with the American blood suppliers.
It is a truly terrible scandal, and what the inquiry uncovered is is an awful testimony of what happened to people. I understand. So our authority is set up with one objective only, which is to pay the compensation that everybody is due. I do understand that there are some police investigations underway about what happened and what was uncovered in the inquiry. As to where we are on seeking redress from American pharmaceutical companies, I don't know. So perhaps we could find out and write to you.
Could I perhaps offer again to talk to you privately, given the commercial sensitivities? The other thing I would just add is the historic nature of some of this, which is obviously part of the damage that has been caused to victims of the infected blood scandal, is the fact this has taken so long for redress to take place. And sadly, it has also impacted our ability to historically go back and take some of the action that we would have ideally wanted to have taken.
Thank you. Yes, we may well take you both up on that. Thank you for that offer anyway. Clive.
Yeah, thanks, Chair. Just coming back to Fujitsu for a second, if I might. Clearly, there are discussions going on, as been referred to. Capital, you said that they're a strategic partner supplier to government as a company. So I think people often scratch their heads and think they've made major failings here, which they engaged in a cover-up about, and yet we're carrying on awarding them new contracts.
And again, I'm really sorry that I can't go into the detail of some of that in this forum. Every single contract that's awarded in government is assessed under the Procurement Act and under the procurement legislation that we have to undertake. I am very happy to take you through some of the more sensitive and I think pertinent information privately.
It's true, isn't it, that the government have changed the approach on procurement fairly recently so that account can be taken of past performance in a more effective way when awarding contracts in the future?
That's correct. So we have new powers under the Procurement Act 2024 that allows us to look at investigations that lead to debarment procedures.
Right. Okay, perhaps we could have a further briefing in the light of that about this situation.
I'd be happy to give you a further briefing.
Just before you go into your question, I think we just need to be, as a committee, quite careful about accusing people of fraud. If we've got specific evidence of that, that's fine, but in the absence of specific evidence, it's quite a big step, and it's a legal step, so just be a little bit careful. Clive.
Okay. Moving on to what was known about Horizon, and then I'll come on to the issues of the LGBT and the Ministry of Defence as well. Just going back to the answers that Gareth and Carl gave to the Chair about the knowledge of likely numbers at the beginning. I'm sorry, I just don't understand how the Post Office in particular did not know who they had been pursuing and demanding payback from. They knew, didn't they? And if they weren't giving that information to you, then they effectively were either hiding it or denying it.
I suspect that their records were so poor, as Gareth was saying, that they did not know at that point how many people had experienced shortfalls through their system. We have, as Gareth mentioned, experienced quite a bit of difficulty getting disclosure of documents out of the Post Office records. There were millions and millions of documents. They obviously knew who they had prosecuted and how many people had been prosecuted. But what we're talking about here is the people who continued to work as postmasters but had experienced some issues, often quite small, for small sums of money, day to day in their time in the Post Office. It was only when the Horizon Shortfall Scheme was launched that they then experienced an influx of people.
Is it that they didn't know, or they didn't really want to find out?
Well, my view is that the people who advised us at the time in 2019 didn't know. They didn't know the scale of it, because they would have had to have informed us as a department and reflected that as a provision in their accounts. I think Sir Wynne will give the categoric assessment of what was known or what was not known at different points throughout that period, but I wasn't working with the Post Office nor in the Post Office, so I don't know.
So the numbers were those people who were not prosecuted but were being squeezed and demanded to pay back money and did so without having to go to court about it. They just paid it back.
Exactly, yeah. So there were different cohorts and there are different schemes that reflect those cohorts, and it can sometimes sound a bit confusing, but Sir Alan Bates represents the GLO group, which went to court. Most of those people didn't have convictions, but some did. And the starting point was how to ensure that that group of 555 people got the compensation that they deserved. Partly that required the overturning of convictions. There were then some other people outside that group who had convictions who have now had their convictions overturned through legislation. But beyond that core group, there's a much larger number of people who experienced problems along the way, but didn't necessarily lose their job or do more than have to put a bit of money back into the till. Now, that was obviously bad for them individually, but it's of a different nature of harm than those people who ended up in prison for months or years.
There's a bit of a quid pro quo on this. I mean, some of the Post Office victims ended falsely up in prison, but it does seem to me that somebody ought to be chasing those people up who either covered it up or gave false evidence in court. And I'm just wondering what government is doing on that aspect.
So step one, as I say, is the report of Sir Wynne's inquiry, and that hopefully will come out later this year. Step two is follow-on investigations and potential action against anyone who is found guilty of a crime, and that is where the Home Office has been working with the Metropolitan Police. There are 100 officers already working, looking at the documents, preparing, and then they and presumably other regulators, if fault is found from, for example, solicitors or barristers or others who have committed bad acts, we would all hope, and I know the victims need, for there to be robust enforcement action taken on the back of the inquiry. But I'm trying to be careful not to preempt what Sir Wynne finds, and there may well be legal action around this, as you say.
I think that it is, you've hit the nail on the head. if the victims are going to get closure, they do expect, on the other hand, those people responsible to be fully pursued.
Completely agree.
Rupert, very briefly, please.
Very quickly, on data, yes, I mean, they were quite confident in prosecuting people with the delegated authority they had. And to your point, Clive, it wasn't, often they were paying back money that was their own money, because ultimately the Fujitsu software was a double-entry bookkeeping system, and there would have been a credit thrown up the other side of it. The question is, what happened to the credit? Because a lot of these people were bankrupted, and they paid the money rather than being prosecuted.
Absolutely.
So this is a massive government error. Basically, the post office is a government organ. It's an organ of the state. So, you know, we do need to get to the bottom of this. And you say the information wasn't there. Well, it was apparently there to prosecute people. So at the end of the day, when I talk about fraud, people knew that this software was deficient. That has actually been proven. We know that. People have admitted it. People have apologised for it. So, look, I mean, this is a shocking abuse of honest, decent people, and that cannot be allowed to happen.
Comment.
Follow up. The people who weren't prosecuted but paid money back.
Yeah.
The post office must have had a record of all the payments back that were made to them. They must have had that.
We need to know what happened to the positive balance. I'd like to know what happened to it, because there would have been a positive balance thrown up the other side. If you've got a double entry bookkeeping system in any company, there will be a positive balance. I'll bet you that got written back to P&L, probably paid out in bonuses to the executives at the post office.
So, Mr. Lowe has made a very interesting accusation today. I don't know whether this is being followed up by either in the general inquiry or whether the government itself is following this up, because it seems to me an important area that should be fully investigated.
I agree that it is important. I think on Mr. Bett's point, we are getting to the bottom of the problems at individual branches through the disclosure process relating to the schemes. So if an individual comes forward to us, we go to the post office, they access the records, and for most years they still have that information. They didn't have it in an aggregated form, but we can get justice for the individual people.
They must have had the individual cases, though. If money's being paid back, there must be records of individual payments back to them that were made.
Well, that's what I'm saying. That is what we are getting disclosed to us from the post office when an individual claims to one of our schemes. On the broader point about where the money went, that is something that I would expect Sir Win Williams' inquiry to pick up. You might well be right in your assessment.
I suspect I am. I don't know for sure, but all these things are shrouded in so much need to know, can't tell, lack of transparency, time lapsing, so nobody actually knows where the truth lies. It's a case of, you know, you move it.
I don't want to pursue this too much because we've got a lot to cover today, but I just do think that Rupert's made a really good point, and if the inquiry doesn't cover it, I think you should have forensic accountants looking at that, because if it was siphoned off the other part of the two-part balance sheet into profit and loss, and therefore into people's pockets in bonuses and so on, that is disgraceful.
Jeffrey, it will have shown up somewhere.
Yeah. Okay, we need to get that investigated.
Back to the point, if I could, Chair, about I understand once a claim is made, that you go back to the post office and look where the money was in the system. But surely before a claim is made, there can be an identification of the money that was paid back. It's there. You can chase the individual examples of it and then ask questions about it. It seems there was almost been a passive approach of waiting for people to make a claim rather than identifying the people who were made to pay money back and going ask them if they want to make a claim.
Well, we're talking about millions and millions of documents, and even managing to find the information for those people who have claimed is, a very big job. I've described to you the process that we've been taking. I realise that you might disagree, but what we've tried to do is respond to those people who come to us as victims and need compensation, and we want to get that to them quickly.
Carl, you've heard where the committee is on this, and we will be obviously making some recommendation.
Back now to Jeremy Pocklington, because similar issues...
we're going to come on to...
sorry, about poor estimates.
Okay, go on.
Yeah. On the LGBT dismissals and disciplinary action in the Ministry of Defence. Again, wrong estimates were made at the beginning about the number of people affected or likely to make claims. But the department knew how many people had been dismissed. They recorded in the dismissal and disciplinary proceedings the reasons why. So why were the department it's so poor at those initial estimates?
It was difficult for the department to understand exactly who was affected by the ban. That is partly because of the challenges around service records. But secondly, Mr. Betts, the scheme set out in the report is actually divided into two parts. There's the scheme for those that were dismissed or discharged. There is also, though, the impact scheme and the impact payments. And particularly in the case for the impact payments, that the impacts of the ban and the horrific, unacceptable impacts that the ban had on service personnel would not necessarily have been recorded in the service personnel. The department worked actually with GAD. We actually adopted approaches to come up with estimates, but it was difficult to come up with robust estimates about the number of people who would apply for the scheme. I know there is concern about the time it has taken to process the scheme. When we come onto this scheme properly, I can go through the latest management information in front of me. We have made progress. But the other issue, which is a general issue across compensation schemes, is there was a fundamental choice to be made about when to open the scheme following government accepting all the recommendations from the Everton review. And the decision the department took in close consultation with stakeholders, attempting to listen to those impacted by the ban, was to open the scheme as soon as it possibly could. That was before all the application processing systems that we now use were ready, and before the independent panel that assesses the impact scheme had been recruited. But that decision was taken so that we could get payments, recognition payments, to those who were in high priority groups as quickly as we could. And as the report sets out, we succeeded in doing that, particularly for those that were identified as high priority. But again, thinking about lessons learned for the future, I think we should have done more to manage expectations about where we were when we launched the scheme. Yes, we're opening it now because in consultation with stakeholders there is merit in getting early payments out where we can, but it will take longer to build the machine so that we can process more of the payments.
Okay, so it's fairly simple where someone was dismissed, so you're gay, you're out. On the impact scheme, more difficult because how people impacted who weren't then removed from the service. You found examples as well of people who were dismissed for other reasons because some sort of agreement was reached. We want you out because you're gay, but we won't put that on the records as long as you don't create a fuss about it. That went on, didn't it?
What Everton recommended was that we had a specific scheme for those who were dismissed and discharged, or discharged, brackets all the equivalent process for those of officer rank, and that there was a specific payment for those recognising those that were dismissed and discharged for those for this purpose, and that was recorded in the service records, and that the report argued that they had the highest impact. What the government decided to do was to recognise that the more people were affected and that it would also introduce an impact scheme for this other group. On the specific issue that you are raising, there is actually a legal challenge underway on this very, very specific example that you are talking about, perhaps where people were asked to resign. So, while like others, I'm limited in what I can say about that very, very, very narrow case that you're referring to there, Mr. Betts.
Move on very quickly to Cat Little and David Foley. We've had examples here of the difficulties and perhaps sometimes avoidable difficulties in doing accurate assessments at the beginning of the numbers affected by these schemes. The lessons being learned for the infected blood compensation scheme, which hopefully will make those estimates more accurate.
Well, I suppose if I start, and David, please do add to this. And I should say I've been involved in trying to assess the numbers of people involved in this scheme for several years, both in the Cabinet Office and in the Treasury. In the Treasury, because we were trying to understand the financial estimates when the scheme was established. And for the infected individuals, it's been a little bit easier because we've had a registered scheme in existence for several years run by the Department of Health. But for the affected and for loved ones, for families, for children and descendants and estates of people who've been affected, we've really, really struggled to identify the very, very broad possible impact that this could have. But what we've done is developed very, very sophisticated modelling using a lot of demographic data, a lot of the information that's available to us through the infected records. So we've done our very, very best, but I think as you will see, the modelling ranges are very broad for the affected. David?
Yeah, so the ranges are broad. Tragically, it's a feature of the scandal. This was a scandal that affected very many people in very many ways a very long time ago. And the inquiry engaged a number of statisticians to make an estimate of how many people were infected. The best estimate they could come up was 30,000 people were directly infected. But they recognised that was an estimate. There's then a question about how many of those are due to be competent. And tragically, a lot of those people who were infected, nobody will ever know that they were infected. Tragically, they died before understanding how they had come to contract that disease. And then if you look at what the inquiry found as well about the destruction of records, the removal of documents, all of that which has happened and transpired over time, it becomes even harder as well to find those people and make sure they were. We start with a really wide range of estimates. We've worked to narrow those. So specifically, we've introduced a registration scheme which allows people to come forward and say, I would like to register an intent to make a compensation claim. We've surveyed people that we've already paid compensation to ask them how many people do you think are connected, affected cases to your range. And we've also looked at, with the help of GAD, what's the right and appropriate expectation about the average number of affected people that a case may have, all of which are helping us to narrow the number. But I should say the nature of the scandal is such that we will never know exactly how many people should be compensated.
Okay,
thank you, Clive. I'd just like to come back to Clive's question. You will have heard, Jeremy, Peter Gibson's evidence on Monday, and he was very critical about how the MOD went about promoting the availability of this scheme. I would have thought it would have been impossible, and he said this in his evidence to us on Monday, at least in that former category that you announced, that those people who were definitely discharged, to have written to every single one of them. After all, you had them on your payroll, you knew exactly who they were. I accept the second category may well be subject to proceedings now, but why didn't you write to the whole lot of the former category?
The policy decision that was taken was that the right way to approach this was to do everything we could to promote awareness of the scheme. Unfortunately, service records are such that they are fragmented and not easily searchable in the way that you are indicating there. Jeffrey, again, that is something that over time can be fixed, but it is a very, very challenging to do that. So what the department did is it has had a plan in place to promote the scheme, including providing grants to Fighting with Pride and Royal British Legion, using a variety of methods, working with local authorities, the NHS, regimental associations, a wide variety of veteran employers, military charities, and others, in order to maximise awareness of the scheme.
Given the doubt that has emerged from this particular conversation, it does seem to me quite dangerous that you've imposed a closure scheme of the 12th of December, because there will be people out there, I am sure, that won't have been aware of the scheme, or if they were in sufficient condition. They might have had mental health problems, they might be elderly and confused, who would want to claim but will not be able to. Will there be a hard cut-off on the 12th of December, or will they still have some grace to apply?
For two observations on that, and I really do appreciate the Well, first of all, the behaviour was unacceptable. Secondly, no amount of money can undo the injustices, those that are affected here. And these payments they are recognition payments. They're not compensation payments. They're recognition payments, as you know. The first thing that I would say is we are doing everything we can to promote the scheme. We are making an additional investment from a specialist who is going to help us promote the scheme for the remaining period that it is open. The reason we have a closure date is because we only have legal powers to issue payments under the scheme for a defined period of time. Again, it was a policy choice that ministers took following the Everton review, that rather than taking longer and legislating for a bespoke scheme, the department ministers decided to use the Supply and Appropriations Act, which only enables the department to issue payments under this scheme for 2 years. So that is the issue that is driving us. The best thing that we can do right now is all work to promote awareness of the scheme, to provide support for individuals, particularly perhaps the elderly or those that are ill, who need additional help in applying, and the department will have the resources in place so that it can process all the applications it receives.
Others may have a view on that, but I'm grateful for that reply. We may well come back on it. And I think Anna wishes to come back on this a little later on. So can we move on to Tris Osdorn, please?
Thank you very much, Mr. Chairman. So by early 2026, 3.5 billion have been paid out across all the schemes. And according to some sources, up to 11.4 billion more is estimated to have been paid out. So what I'm really focused on is where we've seen some successes in some of these schemes, and where there are lessons learned from those. So the NAO identifies that more work is needed on outreach, minimising delays and reaching eligible claimants. So the first question, I'm going to ask it in 3 parts. I don't need each of you to answer because I'm just cautious of time here. So my first one is just, first of all, where there has been success in outreach, do you agree that we need to have in future much more co-production of schemes at the earliest possible stages? That has been evidenced with previous interviews here that just hasn't happened. So that's my first part of the question. The second part of the question is linked to fixed sum or payment options. So we've seen in some of the schemes some early successes around fixed sums. Now, in the earlier evidence session, that has had a mixed response because some people might choose to take the fixed sum because it's quick, rather than because it's sensible for them to have made that decision. But is there evidence to suggest that having a more fixed sum redress scheme might be an early solution to that? And just thirdly, just around improving oversight and processes, I don't want to ask a question around a central provision, that will be covered later, but have there been lessons learned around where schemes have failed currently, and where that has fed into a more what we consider to be a more successful scheme? I'm not after everyone to answer those questions, so I don't know how you want to split those across.
Shall I start? And I've probably got very brief answers to each of your questions. So firstly, your question about co-design, I think is really, really important, and I obviously watched the testimony on Monday. What we have certainly found in infected blood, and I would observe across all of these schemes, is that we started this session on trust. Trust is absolutely essential, and the only way that you can build trust is if you co-design with the victims, the communities, the families that are impacted, to set up schemes that they understand, that have been transparent, and that we've designed the way in which schemes operate around them. Now, depending on the type of scheme, and I think this is a bit of a catch-all to all of this, is every single scheme that we have, and there are tens of compensation schemes across government operating at the moment, they are all very different. But I think co-design as a core lesson and a core principle in building trust is absolutely essential. On your question about fixed or variable, I think there is always a choice in the design of the scheme. So I think what I learned from the infected blood compensation setup was we'd already had interim fixed payments that had gone out. It just simply wasn't enough, and it simply wasn't transparent enough. And that's why we took the decision to spend a significant amount of time developing a very bespoke tiers and tariffs, expert-driven, regulated scheme. And you will know as a committee just how complex that scheme is. And there's a trade-off between transparency, pace of payment, ease of understanding, and being very, very tailored to the very broad range of circumstances that a scheme may be seeking to address. And I don't think there's a sort of generic answer to this. You've got to weigh up the lessons learned on both of those different approaches and find the right answer. And then finally, on an example of failure where we might have learnt, and I'm very grateful especially to David and Carl, who have spent a lot of time working across government to make sure that we have a network and a community of best practice to learn lessons. I think one of the things, one of the first decisions I took as Permanent Secretary at the Cabinet Office in 2024 was to look at how you build trust and set up the structures independently of the organisation that has caused the harm in the first place. And the first bit of advice I gave to ministers was to set up IBCA at arm's length independently away from the Department of Health.
Thank you very much.
Come in with a couple of quick answers. So firstly, on outreach, Sir Alan did acknowledge on Monday that we had consulted and worked closely with the group. We met 10 times with Sir Alan and the legal representatives. I think at the point when offers were then issued to people became a bit unhappy with the amounts that were issued, but we did actually do the co-creation. I think we probably made it a bit too complicated, but some of that complication came from consulting the claimants, and we've learned from that and applied it particularly to our most recent scheme, the capture scheme. We have also learned from the infected blood scheme and its broad approach where there's a holistic assessment rather than a very detailed legalistic head of loss by head of loss approach, and I would advocate that for anyone who is setting up a compensation scheme now in light of my experience, and that, as I say, is what we're doing on capture. And then finally, I think you rightly highlight fixed sums. It was a game changer for us on the Horizon redress schemes, and I wish that we had thought to introduce it when we first launched the schemes. The £600,000 payment for anyone who has had a conviction overturned is very meaningful, and we've had 492 of the 535 people who have come forward following our legislation to overturn all the Horizon convictions accept the £600,000, and that gets them through very quickly. They of course don't need to accept that, and they all have legal advice. We're not forcing them to take it. They can consider whether it's the right option for them, but I'm convinced that for the vast majority it is a good deal.
Can I build on that? Because I think you make a very good point on this issue about fixed payments or versus tiers and tariffs. I think my reflection, particularly after watching the evidence session, is obviously different claimants will have different views about how they want to be treated. Some will want to be heard, have their specific situation heard, and also the redress tailored around that specific situation. Others, frankly, through the injustice and how they've been treated, want to have as little to do with government as possible and have the speed of a fixed payment. So I think my reflection, why I was keen to bring in fixed payments into the post office scheme when I was responsible for it, was to have that option. I think there's a delicate balance again to strike to make sure people don't feel forced to accept it. Given the unacceptable delays in terms of payments today, people can just feel they need to. That's why I think the legal advice in the post office scheme is important. So for me, one of my reflections is giving claimants the choice of the options around either tailoring, maybe taking a little bit longer but being heard, versus the speed of redress.
Thank you.
Can I give a very concrete example of the importance of co-design, which was something that was at the heart of how the department attempted to build the recognition scheme that I'm responsible for. We had a stakeholder group of LGBT veterans advising us. We also actually employed a KC, an independent KC, to advise us specifically on fairness as well as we were designing the scheme. It was that engagement that led to the advice and the decision to establish the impact scheme, which went beyond the recommendation in the independent review that the department had undertaken. And it's also led to changes, for example, in the schemes that we identify as priority cases. We added the financial hardship criteria as well. So there is real benefit and it does promote real change. It also, Geoffrey, your point at the start of the hearing, building trust and confidence is so important, and that is, and that can really help do that sort of degree of co-design, responding to the points that have been raised and engaging openly and transparently.
Thank you very much.
So, Geoffrey, do you mind if can I come in on that point as well? Is that please?
Course.
Yeah. So on co-design, we're working really hard to try and make that happen. So we employ some people with lived experience. We call them user consultants in our organisation who can both directly advise and look at what we're doing. We've got a community advisory panel who advises the board on all of its decisions. We conduct our board in public so that everybody can see the decisions that they make and how they arrive at them. We have community-driven design, so before we decide on any big feature of how we're going to deliver the scheme, we engage with the community and its partners. And we've been doing drop-in centres the length and breadth of the UK, where not only representative groups but individuals can come and ask what's happening in the Infected Blood Compensation Authority and how is it going to work. And then just on payments, we offer both. We offer fixed payments or periodical payments, or indeed support scheme payments. That is a really big decision, and I think the key to getting that right is ensuring that people have got independent advice for them. So we offer and pay for independent legal advice and independent financial advice so that people can make the appropriate choice of their position.
Thank you. Thank you,
Are you
Mr.
happy?
Yes, no, we're cautious of time, sir.
I'm going to call Anna Dixon next because she's got to leave for another appointment. So Anna, please.
Yeah, I'm very grateful, Chair. So I just want to come back on some of the points around the experience for those claiming, and particularly for the LGBT veterans scheme. We heard in response to questions from the Chair about the difficulties of finding people, but even those who have been identified who have submitted evidence. I have a constituent, Victoria. She was 7 years in the Women's Royal Army Corps. She was thrown out. Obviously, it was a very brutal experience and common to many other veterans, led to family breakdown and sort of splitting up from parents as well, disowning her. So we have heard that the actual process is re-traumatising. Those were the words that we used in our pre-panel, and echoes really the experience of my constituent. So could, particularly Jeremy, you give me and my constituent some reassurance that you're doing everything you can to make sure that the process of producing the evidence to get the claims is as humane and empathic as possible?
Thank you. First of all, I'm distressed to hear about the case that you're talking about here, and it really was unacceptable behaviour that serving personnel were on the wrong end of, and I don't think money can really in itself undo those injustices. So this is very serious. We're very conscious of the impact of our scheme and the risk of re-traumatising that you highlight. We have worked with stakeholders and with the community to make the scheme as simple as we possibly can. And in particular, applying for the dismissed or discharged scheme is a very simple application process. For the impact scheme, by its nature, we do need to understand the impact that the applicant is seeking to be recognised. So we do ask for testimony from of their experience from applicants. The approach that we take, though, is we very deliberately have taken a decision to apply what we call a reverse burden of proof. So we accept what we are told, and the independent panel make a judgment based on that, unless there is very clear evidence to the contrary. That's also why we have provided support to veterans group, including Fighting with Pride and others, in order, though, also to help those who are applying to make their application. And we're very grateful for the individuals who are prepared to put down to set out their testimony so that we can offer a payment.
Can I clarify there's no legal support, is there?
We have deliberately made a decision to establish a scheme that does not require legal support, so we don't provide legal support. We're asking people to set out their testimony in their own words, and then we have established an independent panel, including with LGBT representatives on the veterans on the independent panel, who make the assessment. Yeah. But it's not this is a recognition scheme, it's not a compensation scheme. And we have made policy choices to set the scheme up in this way.
I mean, given that and the reverse burden of proof, I would just say I don't think that is the experience of all veterans. I think they feel they are still having to prove that they, many years and sometimes decades after the incident. Can I just come back to a point you said about management information and that you had up-to-date information? The latest we have is that you're claiming around 97% of payments have sort of been approved or processed. But actually the truth is less than half have actually been paid out, i.e. settled. So many veterans are still waiting to get their, I was going to say compensation, but you keep correcting, their recognition payment.
It's probably simplest just for me to give you the figures that I have. And I think that the issue might be the distinction between the dismissed and discharged payment and the impact payment. So first of all, for the dismissed and discharged payments, we've received 1,097 applications, have made decisions on 1,067, 930 have been approved, and 924 payments have been made.
Okay, so that does sound a higher percentage. When you say paid, actually veterans in receipt of that money.
That's payments made. It does require the individual to accept the payment for the payment to be made. Can I do the impact payment is where there is there is further progress to be made. 1,250 applications received. 692 have been decided, and 646 have been approved, and 604 payments have been made. The issue with the impact payment scheme is there is an assessment about the impact in which one of three tiers the impact should qualify, and that's a decision for the independent panel to make. We have expanded capacity in the independent panel. We've appointed a second chair. The panels are now meeting multiple times each week in order to process those claims as quickly as we can. And we will expand the number of panel hearings if we need to do that. But inevitably there is a delay because there is this additional step in this process.
So how confident are you that you'll clear this sort of backlog of, you're about at half of those cases at the moment? Is the main block of the panel, or are there other factors?
It is the process worked through the panel. I'm very grateful for the work of the panel members and the chairs. We are determined to get this through. We will process all the claimants that we receive within the time that the department has available to do that, to make sure that we can pay everyone who's applied and has qualified.
And may I ask a small supplementary on the infected blood, if I may? So again, we've received data that fewer than 500 people have been paid compensation since January, and it does seem that there are significant delays and little progress. And again, from one of the case studies locally, they're suggesting to me that if your process is delayed, there's also a risk that your total compensation received may actually be less than if your case was settled early. So these are not only causing delays in terms of ongoing distress, but they may actually impact the amount people ultimately get. So I don't know if you could address that, please, David.
Sure. We were created 2 years ago, and at that point there were just myself, the chair, and nobody else and nothing else. And in those 2 years, we've managed to get to a point where we have started 4,466 claims, paid 3,287 of them to a total of more than £2 billion. We always knew that at this point the flow would slow down because we'd taken some very deliberate choices. We took a deliberate choice last year to really focus on the living infected and registered cohort. This is the group of people who were directly infected and with contaminated blood. This is a group of people who had already been registered with a support scheme and had been supported through there, and in many cases, have had a lifetime of disease and therefore. And with the help of the inquiry, in its second set of hearings, we decided that was the most important group to focus on. We then knew that we would have to develop the other parts of the scheme. So those are cohorts that are the affected, so that's parents, children, siblings, carers. The living infected, never compensated, so people who were either ineligible for previous schemes or had been unable to prove, cross the burden of proof for those schemes. And then the deceased infected, so people who had been infected but had died and therefore a beneficiary of the state would take it. It was a very deliberate decision that said we would concentrate on the registered living infected first, and then we would develop the next set of schemes. And at this point, it is really important, and this is the test and learn approach that we're taking, that we invest the time to be able to understand what it takes to make those cases flow smoothly and quickly. So you start with a small group and you learn really important lessons about that, but that means that the flow comes faster later. And I can evidence that in how did the living registered infected group go? Well, we paid the first living registered infected person in December 2024, which was only 4 months after the regulations had been created. We had about 244 live cases in the living registered infected cohort in March 2025. This is the learning phase where you are starting with a small number of people. But by the end of the year, we had paid more than 3,000 people. And I expect exactly the same sort of acceleration to happen on all 3 cohorts that we are developing now. And indeed, if you ask me to make an estimate, my estimate would be that by the end of this financial year, we would have started all of the deceased infected cohort and all of the living infected, never compensated cohort, and the vast majority of those would be paid, and we would have done more of the affected cohort as well. But it requires an investment in time and effort now to be able to get that acceleration.
Yeah, I think you need to explain this test and learn, because it seems from those who gave us evidence representing claimants that they didn't really understand why everybody wasn't being sort of processed in an orderly fashion. I mean, obviously, my constituent is living, got infected with Hep C in the 1980s, and was also already proven and in receipt of the severe condition mechanism. So can you touch on this point, though, about those who are in receipt of ongoing payments, that this is going to get deducted from compensation? I think this is the point about delays in the living people when you're dealing with their case. So if they were lucky enough to be in your early test and learn, great, but if they weren't, they may end up getting money deducted from them further down.
Yeah, so the calculation of the claim is exactly the same at each point in which you do it. What they're referring to there is in the regulations, which we're duty bound to comply with, it sets out that after the point at which the scheme came in, prior to that, the government does not discount any of the support scheme that you have already received. Yeah. Subsequent to that, it says actually it makes sense to count that as compensation that is part of the scheme. And so whether you were paid in the first tranche or the last tranche, those rules apply equally to everybody.
Okay, I may want to follow this up in writing, because I do think that there is some unfairness in this system with prior compensation being deducted under the new scheme, which I don't feel I've quite had a full answer to, but I don't want to take any more time with the panel. Thank you, Chair.
Well, we will return to that subject. I'm going to call Matt to main now, and following which I will take a break. And in the second half, we will more want to come on to how we design schemes in the future. But for the moment, Matt, the present, you.
Thank you very much, Chair. And I'd like to ask some questions relating to the timeliness of the claims process around the Horizon and Windrush scheme. So my questions are directed primarily at Mr Davies and Mr Cresswell, but obviously anybody who has a contribution to make is welcome to say so. So I'd like to know why you think there is such substantial variation in the time taken to claim on the Horizon and Windrush schemes, please.
Yes, I mean, yeah, that sounds good. I mean, even now we are still waiting for claims from a significant number of people on the different schemes. So there were 21 people whose convictions were overturned by the courts who have not applied, even though their convictions were overturned in 2021. We talked to the claimant lawyers because each of them is recognised with a lawyer and represented by a lawyer, I should say. And what the lawyers say to us is that it is hard to get instructions from these individuals because they are either vulnerable or unwell, or they want to wait until the Horizon inquiry completes. Now, obviously, from our point of view, we're keen to get money out as quickly as possible. We have paid interim payments, but I think those are factors that affect how long it takes for people to come forward. The same is also true of the GLO scheme, the one that Sir Alan Bates talked about on Monday, where there are still 10 people who have not submitted a full claim. And so we're doing what we can to encourage people in and provide support for them.
And so would you, just to follow up, sorry, I think you said that the inquiry is due to complete in the autumn, so would you expect a sort of flurry of those 10 and 21 people to claim afterwards?
Yes, I mean, the timing of the inquiry is a matter for Sir Win. My speculation is that it will be later this year. What we have also found on schemes is that when we announce a closure date, there is then a surge of people that come forward. Right. And so we have, on the GLO scheme, announced a closure date for new claims of the end of July. And we're obviously working with claimant lawyers to understand whether that is helping the individuals or whether they need any more support. And we have said that final payments under that scheme should be completed by the end of this calendar year, whereas the scheme that's there for people who have convictions will remain open for longer than the end of this year. So it is possible. After the last inquiry report, we did see more people come forward. The other thing we haven't talked about much is restorative justice. We might want to come back to that later, but we've discovered that giving victims the opportunity to tell their story and to get a personal apology from the post office officers or even the department has been quite helpful in unlocking some of this sort of concern and vulnerability to get people to trust the schemes a bit more.
Okay, thank
Shall I
you,
come on
Mr.
to
Davies?
Windrush? Obviously,
yeah.
I had the opportunity to review the scheme coming into the department. I think when I stand back, the NAO report set this out very clearly. The original mistake was opening the scheme before the caseworking capacity was stood up. So right from the start, understandably, you had an initial rush of applications, but without the capacity and capability to actually be able to deliver them. And so, frankly, the scheme was on the back foot right from the start. And you saw the backlog peaking then around 2023 at over 2,200, which is completely unacceptable. I think that speaking to the team in the unit, they've done excellent work to really reduce processing times. At one point, I think at the worst point, the processing times from start to finish was over 15 months, completely unacceptable. They've increased that now 7 times faster, so 2 months. What happens now, applications have a preliminary assessment within 6 weeks, and if they are entitled, they'll get an initial payment as well of £10,000. But then the average time for applications in the last 12 months has been 2 months, as I touched on. The other thing I was particularly concerned about were the number of applications that have been in the scheme for over 12 months. Some of the real long tail, because sometimes a lot can be hidden by averages. At its worst point, over 368 of the work in progress, the WIP as we call it, was over 12 months. That's now been reduced down to 45. So again, significant work from the team. I still wanted to explore exactly why any case should be over 12 months, because that felt unacceptable to me. So I wanted to really understand where the barriers were happening. Typically, this is with the more complex cases. So potentially maybe when there is a deceased estate without probate, and so we have to work with the family to put in place probate arrangements. Sometimes you need to establish power of attorney as well. As ever, and we'll probably touch on this in the session about how we design for the future, it's how we get the balance right between having a light touch approach, as Jeremy touched on, that sort of balance of probabilities, whilst preventing fraud and getting that right. So typically the longest cases are where either it is, to say, it's a deceased estate, where we've got complications with power of attorney, or when sometimes a claimant family, for understandable reasons, have wanted to pause the process and then they've come back to it later.
And do you think that some of those early complications have had a knock-on effect on subsequently people making a claim or not?
Yes, totally. I think it's back to the people who are applying to these schemes have suffered an incredible wrong, horrific wrong. Quite rightly, we are not trustworthy in their eyes, and we are not because of the failings that the state has done over those years. I think then, and to compound that by large backlogs at early points, just compounds a sort of sense of not taking this quote unquote seriously. We have needed to work through this. To say, I think the team has done excellent work, both in terms of just the process of accelerating the payments, but also the significant engagement that's gone on with the community and community groups over that period. But I think you're right. I'd completely agree. I think setting up and opening a scheme before the capacity is in place is a real issue.
Thank you. And just finally, you've touched on, both of you, the sort of reduction in length of time that's gone on. Can you just talk a little bit about what interventions you've made in order to achieve that? What's happened that's different?
Sure. I mean, the biggest intervention is the one I mentioned earlier around fixed sum offers. So that has sped up, as you will see from the NAO report, how long it takes for claimants to get through the scheme very significantly. I think we have also learned some lessons in the GLO scheme about the number of stages that you might describe as challenge or appeal stages. So as I said earlier, we designed the scheme in consultation with the Justice for the Postmasters Alliance, and we built in quite a lot of steps where a claimant could put in a claim, the department would make an offer, the claimant could then challenge it. That could happen 3 times. There would then be a non-binding panel, an independent panel, and then a binding panel ultimately. And obviously the independence is critical and something that I hope we'll sort of return to later on. But I think on reflection, that has been too many steps and has been a bit of a cause of frustration for the claimants, and it has led to lengthening of how long it takes to deal with claims.
Yes.
As a result, we have looked more with claimant lawyers where there were fundamental issues such as causation, where a claimant will say, I had this thing happen to me, but it is unclear whether it was really caused by Horizon or not. We try to fast-track cases to the independent panel as quickly as we can, rather than end up going backwards and forwards, which I think can be traumatic, to take your colleague's word, for the claimants. And I think that moving to the panel more quickly is an intervention across schemes that in some situations will be helpful.
I would touch on 4 things. I think the most important thing has just been scaling up the unit. We now have over 250 people working this unit. Combined with that, we have I think probably the biggest thing that's made the difference is having the single named caseworker. So rather than just it being a black box, you have consistency of relationship, and that's been combined with quality of training. So we have a training program called the Face Behind the Case, which is all about remembering the individual here and the family that's suffered and had injustice done to them, rather than just seeing it as a number in a factory process. I think I've been impressed by the advocacy groups and the support groups, so people like the Caribbean and African Health Network, Croydon BME, the Windrush National Organisation have been critical in helping us simplify some of the schemes, simplify the way in which the scheme application form and process works, and providing support to the victims through this.
Okay, thanks very much. Yes, that caseworker element came up very strongly on Monday, didn't it? Thank you, Chair.
Just before I take a break, I don't want to leave this subject entirely, because I want to establish a principle here. And your 2 schemes that you had been talking about, Windrush and Horizon. Windrush, the longest claim, took 1,282 days. That's 3.5 years. Horizon, the longest claim, took 1,395 working days. That's 382 years. Now, I hear what you say, Gareth, about an announcement before the infrastructure was set up. But as a principle, when government announces these schemes, an expectation is set up. An expectation is that their claims should be made and settled in a reasonably prompt and acceptable timetable. So can we, as a principle, all agree that those length of time to take the longest claims is unacceptable?
I mean, claimants should be able to get redress within an acceptable time frame, and obviously 1,200 days sounds completely unacceptable. I dug into specific cases. I'm cautious about how much individual detail I want to, we can reveal in a public forum. But just to say, the longest cases typically, not always, but typically, will be, as I touched on there, where someone typically has, there's a deceased estate, the claimant family may want to pause for understandable reasons because of distress and grieving. They will then the case will be paused and then reopened at subsequent points. So there's some, I don't want to say all of it, some of that will reflect quite rightly the claimant wanting to progress at their own pace. However, what I'm keen to ensure that when the claimant wants to progress at speed, we have the system set up that we're able to deliver on that.
I agree with what Gareth has said. Broadly, of course, the principle seems sensible. We give people 6 months to consider a GLO offer, and they can extend that if they need more time. So I think we need to just be careful that the implication of your principle isn't that we set deadlines that are tough on the claimants, because that would definitely be traumatic. We do need to go at the pace that is right for the claimant, and some of the figures in the NAO report mask the delays that are on the claimant side.
So, Gareth, can I just clarify the figures that you gave to Matt? Because it may be, I'm sure it is, that your figures are more up to date than, of course, there has to be a closure for the NAO's reporting.
Yeah, exactly.
But they say that as of January 2026, this is in relation to Windrush, there were 27 claims that had been in progress for 12 to 18 months, and a further 15 claims which had been in progress for longer than 18 months. This is out of 528 claims in progress at the time. As you say, are your figures more up to date than those figures? When are your figures up to date?
They're they're at the end of the financial year.
Fine. Okay. Thank you very much. Can I thank you all for what you've said so far? We're going to take a short break. I think if we could be back here at least by past, but possibly before. Just be careful that there will be microphones open. And we look forward to having you back. And I think we're going to start, please, with my very able deputy, Clive Betts.
Thank you, Chair. Moving on, perhaps just begin with Gareth and Kat to begin with about the availability of legal assistance and funding for it to help people who are engaging, making claims, or not sure when they can make a claim. Is it adequate?
Well, I still think it's quite early days. We're learning a lot from the assistance that we provided. And I should say we also provide financial assistance because for many claimants, these are life-changing sums of money. And quite often they choose to take that advice together and take time to think about it. David might want to add, but I think so far we've had very positive feedback and relatively good take-up. We were quite concerned at the start because the take-up wasn't as high as we had expected, but I think that's changing as people understand the service and understand that it's independent and can be trusted. But David?
Yeah, so we offer everybody both sets of independent advice. 46% of people so far have chosen to use the legal support and 34% the financial support. Now, of course, is our offer. They may be getting, for example, financial advice somewhere else themselves. It has been a very strong element about people having trust in the scheme. And the firms we work with, particularly on the legal side, are firms that have experience of the contaminated blood scandal. They may well have supported people through the inquiry and therefore have built up that bonds of trust. So they have been very influential, they've been very important, and as Kat says, these are big decisions for people about how they take a significant sum of money.
And coming into the Home Office, one thing I was struck by was that the Windrush scheme does not offer legal support. Because in the Post Office, obviously, there's extensive legal support, which I'm sure Carl will want to touch on. And I sat down with the team to understand the history and the decisions that had been, the policy decisions that had been made. Part of the original sort of genesis of this was a desire to make sure the scheme was not seen as confrontational, seen as an opportunity for the victims' voices to be heard. The member said just previously that the risk of these schemes is they become re-traumatizing or triggering or whichever language you want to describe. However, there are very different views about whether that's appropriate or not. Some claimant groups are in very different places on this. I'm very conscious of the Justice Report, which has looked into this, and I spoke with the Windrush Commissioner, Reverend Clive Foster, on this, and I know I've asked him as well, and he is looking at this about whether there is differential, whether the impact of having legal representation or not changes the way in which the scheme functions. We've invested in advocacy and community engagement. This is the core question, is the policy decision was not to have legal support, but I say I'm looking forward to seeing what the Windrush Commissioner has to say on this.
And on the Horizon schemes, the DBT-led schemes do have access to legal advisors up front, as I mentioned earlier, and we have very good relationships with those lawyers. I have sometimes worried about the capacity in a sort of small number of legal firms who have the expertise. For some of our later schemes, we've tried to broaden the market by allowing a broader range of people to advertise their services effectively. If they sign up to a legal tariff, we'll then list them as a law firm. So any legal firm that's happy to sign up to the tariff is then offered to claimants. And we found that has diversified the range of lawyers that are available. Sometimes there are capacity issues, I think, within a claimant's law firm that I think in some cases has contributed to delay of claims coming through. So it's not just, as we were discussing earlier, the vulnerability of the claimant. So I think it is something that we keep an active eye on and we discuss regularly with the lawyers. But no, the lawyers are essential to communicating to the claimants in the DBT schemes.
Can I come back to Jeremy Pocklington then, a slightly different position, I think, at the MOD, where a grant's been made to Fighting with Pride in the Royal British Legion to help support applications. Fighting with Pride have told the committee there's insufficient support, and essentially the MOD's attitude has been, well, the scheme's been designed so claimants do not need legal advice, though I think as we had a discussion previously, there are some sorts of claims about whether it's a dispute about the reasons for discharge or dismissal, where legal advice may be necessary and appropriate. Is there a problem there that you recognise that needs addressing?
So, as we've already touched on, this scheme was designed not as a deliberately as not as a formal compensation scheme. It was designed, policy decisions were taken that it was a recognition scheme that would require personal testimony in the case of the impact payment, but that this would be designed in such a way so that it did not need legal advice. The specific legal challenge that we're referring to here actually relates to the sort of technicalities of whether someone was dismissed or discharged. So it's not actually about the testimony in the impact scheme, and we've designed it this way. The judgment that the department made was to provide the additional support that you've referred to. We continue to monitor that. The decision that we have made is that at this stage, additional support to a communication specialist, an outreach specialist, was the right thing to do to maximise the opportunity for people to apply before the closing date for the scheme. But obviously, these are judgments that we've had to make. What is the adequate amount of support to offer? We think we're in broadly the right place, but obviously we will continue to discuss with Fighting with Pride and with the Royal British Legion about this.
Let's go back to a principle which probably might apply to all schemes. Just thinking back to the Hillsborough law about the duty of candour, but also about the fact that those who are affected by a disaster of whatever kind or because of an act of public policy should be as entitled to the same legal advice as the public authorities are in dealing with any claims that are made. Presumably that in cases like the MOD LGBT claims, the department is taking its own legal advice about whether to pay money, so shouldn't the same amount of assistance on that principle in all the schemes be available to those who are making claims?
Just perhaps one thing up front, and I'm glad you mentioned the Public Accountability Bill, because I think this is an important part of the lessons learned and how we avoid the need for compensation schemes, hopefully, in the future. We need to create that culture of candour and accountability at the heart of the state. But the bit you're referring to about the parity of law is an important principle which is currently being debated as part of the passing of that legislation. I think what I would say up front is that that is designed with a future set of principles in mind, where also we have different provisions, we have different professional and legal responsibilities, and I think there's an important part of the debate as to how much of that is prospective as opposed to something that's meant to be a kind of retrospective piece of thinking. But ultimately, I think particularly from the experience that I've had and from what Gareth has said, I think where you've got very complex legalistic schemes where you do need to ensure that you've thought through the legal ramifications for you, your family, your loved ones, your estate, it is absolutely appropriate and right for the state to put in place legal support and for that to be part of the overall scheme design.
Okay, so some of the changes are essentially about looking to the future, about future schemes, future arrangements. The question you mentioned, Cat Little, is whether they should apply retrospectively in any way at all.
Yeah, I think yes.
Who's going to make that decision and when?
That will be for the government as part of and for Parliament. I mean, this is a carried forward piece of legislation into this session. As you know, this is about to progress further, I hope. So, this is a live, important part of the policy making procedure in both houses.
Okay, I think that's something we probably want to follow up on in due course. But let's say, Jeremy Pocklington, just come back to
to come back on the question, and so Kat's the expert on that particular legislation. Just the additional thing I would say is the independent. There are no lawyers on the independent panel. I've just checked. So it's not that we are assessing these with lawyers around us. This has not been designed in that way. It has been designed as a recognition scheme, not as a formal compensation scheme. These were policy decisions that were taken following the Atherton review. There is that very specific, on a very technical point, there is that case that you've referred to. But that's only a very small element of this. This is a different approach and a different style. Ultimately, the committee can reach a view on whether this is a potential approach to be used in future, or whether departments should adopt a different approach. But that's not the approach that we have decided to take here.
That's one further issue that was raised before that you answered about the cut-off date, and referred to the fact it was a 2-year period when it had been agreed that there was supply available to meet any costs. I think most of us would feel that there's bound to be claims put in after that date, and as with the Horizon scheme, where there was a date and then it was extended effectively because claims came in. If more claims came in, it could be for ministers to decide, could it not, that date could be extended.
Would really encourage us to focus on doing everything we can to get the maximum number of applications in before the deadline of the scheme. That really should be absolutely should be our top priority. My worry about indicating we can extend the scheme is the department has legal powers that only give it the power to make payments for 2 years. I don't know that there's a sort of contingency that could be done easily if ministers were to want to do that. But obviously I recognise that this committee may have a view on that question. But I really do think our focus right now should be on maximising the number of applications that are delivered by the deadline, putting all our effort into that, because I'm not here with a contingency that I know is workable.
Well, I'm not in any way disagreeing, so nobody would, that the claims ought to be made as soon as possible, encouraging it and getting everyone put a claim in and getting paid in a good time is right. I'm just a bit confused why it would be so difficult to do a contingency if one was needed and agreed upon by ministers.
Ultimately, it comes down to the challenge of getting legal powers for something like this. That is the heart of the challenge. But again, obviously, I recognise the committee may have strong views on this. It was the Everton review itself that recommended going down this route of using the Supply and Appropriations Act, 2-year scheme, rather than the alternative route, alternative course of action, would have been to legislate for a bespoke scheme that could have had different arrangements ultimately decided by Parliament. And that was the core decision that was taken because of the priority that's attached to making payments quickly. But that is ultimately the key policy decision that was taken.
So Geoffrey, could I just to
David,
clarify?
Yes.
So this rule that Jeremy is talking about is the new services rule, which is managing public money and stems from a PAC recommendation in 1932 that ongoing services should not be done solely through Appropriations Acts and should have specific legislation attached to them. So while, as Jeremy says, anything up to 2 years can be done just through supply, if you want to do something beyond that, the requirement is that there is specific legislation attached to it.
Very helpful.
Right.
Thank you. Sarah Green, please.
Thank you, Chair. I'd like to turn to trust and transparency, and I'd like to address my questions to Carl and Gareth, if I may. I think the committee would be interested to hear, based on the pre-panel we had earlier in the week, I think we'd be interested to hear what feedback you've received in terms of the level of transparency in the claims process and what steps you're taking to address that feedback for your respective claimants. So if I ask you first, Carl.
Yes, absolutely. And I think this is an area that it's fair to say we worked on during the passage of the different schemes. We have improved the guidance along the way, partly in response to feedback from claimants who have said that they would like more information about what to expect through the process. So we include indicative tariffs, worked examples and so on. So the claimant up front knows what to expect when entering. In most of the DBT schemes, as I say, we have claimant lawyers who represent the claimants. And so on the question of how does a claimant know where their claim is, the best source of information is directly from their claimant lawyer. And we meet regularly with the claimant lawyers to take stock of where we are on individual claims. I know there's been some talk about whether there should be a sort of a tracker that could be externally accessed by a claimant. I've heard that suggestion, but it's not something that we currently do. My judgment is, because the claimant lawyers are in so much contact with us and with the claimant, that it's probably not so much of an issue where there is a representative like that. We have considered it because it's been raised previously, but our emphasis instead has been upon making sure those relationships work well. We similarly, on some of our schemes, have dedicated caseworkers who will track a claim to ensure that we have a good grip about where a claim is, so that we can then communicate that to the legal representative.
I've heard similar concerns around the level of transparency in the system. I think it's fair to say when the scheme was initially set up, I think I mentioned to the member, it was initially a bit of a black box. You'd put your application in, and then because of the capacity issues in the team, it would often take over 5 months before even that initial allocation was done, which is obviously totally unacceptable. I think the team has done great work now in terms of turning that around. I say the allocation now happens within 6 weeks. There's a name
The allocation happens within 6 weeks. So I've submitted my claim. What does that mean?
So what that means is within 6 weeks, typically that's sort of the backstop, you'll have a named caseworker. There'll be an initial review of the claim, and if there is strong evidence that there's an entitlement, you'll have an initial payment as well for £10,000. So, but what that means is you've got a named person that you can speak to, and I think that has made a difference. I think there's a very valid question which I've been reflecting on. I'd be interested in the committee's views around should we make more of that just easily and transparently available for online systems rather than always having to work through the individual case.
That's an active conversation you're having at the moment.
Really looking.
That's really helpful. Thank you, Chair.
Can I just add to that? Is there a place, the NHS now has got an app which works pretty well, and it guards privacy. Is there a case for, across the board, when we design new schemes, always having an app available at the beginning so that every applicant can track where their case has got to?
I would say we should have a range of channels to match the very broad range of people who are impacted. So an app might work in certain circumstances, but I think about the infected blood scheme, there are many very sick and dying people who may not see that as the best and appropriate way of us communicating. So I think our job is to make sure that there are appropriate and transparent channels on a number of different digital channels available.
May I just add quickly to that the capture victims date from even further ago than the Horizon victims, and we find a lot of that group want to operate with us in paper form with letters and so on. So we would need to be careful that anything that was introduced didn't exclude people who were vulnerable in that way.
Thank you. That's it.
Matt, please.
Thank you, Chair. I'd like to ask about, or to continue asking about the trust issues, and to ask what actions you're taking to rebuild trust with the individuals affected by government action or inaction, specifically around the Windrush and the LGBT compensation schemes, please.
Yep. Shall I start on Windrush? I think the first thing to say is you don't rebuild trust overnight. There's been a catastrophic failure of the state here, so we need to make ourselves trustworthy as a first point. This is what I think is really important about these sorts of schemes. The risk when we start looking at metrics and performance data is we sort of see it purely as, if you like, a sort of transactional process. And that is important, and certainly for some claimants, they just want to have the redress and be able to move on. Others, as I say, want to be heard. There's a number of things we've been doing. One is around the extent of community engagement. We've established a £150,000 fund for community events, plus the £1.25 million fund to provide advocacy support. In particular, within the Windrush unit in my department, it is not just caseworkers. There are also people who are responsible for outreach and engaging with the community. So we've attended over 86 events in the last 12 months, just to give you sort of an indication of what we've been doing. I think one of the biggest differences is the creation of the Windrush Commissioner role, who can act as a focal point. And I was pleased to see coming into the department that is not just around the operation of the scheme, important though that is, it's also around thinking about how we can ensure these sorts of scandals and failures do not happen again. And so thinking through how we actually ensure that we have the voice of the British public at the heart of the department. Like in any large organisation, there's always a risk that organisations look internally, not externally, and so that's going to be a key part of it.
And do you have any intentions to publish the outcome of that consideration,
or the way in which...
In relation to making sure that it's not going to happen again, what the lessons learned are?
I don't want to give you false assurance. I haven't got a plan in place in terms of timelines and deadlines. But yes, I would want to come back to you in terms of exactly what we're doing. But I see this not as a sort of a once and done thing. This is changing the way in which the department needs to operate, the way in which officials think through the consequences of their actions, and are ensuring that ministers have full and rounded advice.
Thank you.
Perhaps add some additional areas in terms of the importance of building trust, obviously key. I think, first of all, I'd say, and this perhaps comes to the sort of, should the department be responsible, or should someone else be responsible? The thing the MOD did was we established an independent review. So it was the Everton review was established in order to create the sort of, to engage with the community and to provide recommendations to government about what was the appropriate way forward. So I think there is a case for providing a degree of independence. And actually reading that review, preparing for the hearing, the personal testimony from those affected is incredibly powerful. And actually it led to a very quick and rapid response from government. As well as the importance of co-design, involvement of representatives from the community, being responsive for feedback, working with their representatives. The other additional area we've not yet talked about that I think was particularly important for the Ministry of Defence was also to focus on non-financial recommendations. This is, I've said twice that money can't undo the injustice that people felt. And for us, our experience has been that the non-financial recognition has been very important, whether that is the letter of apology from the service chief, it's the replacement medals, the replacement beret, it's the invitation to the regimental dinner, the Etherton ribbon that we've introduced, restoring rank, the service records. All these things have helped for some, not for everyone. But the department has received a lot of positive testimony that these went some way to right the wrongs from the past.
Thanks very much, and you preempted my next question on the basis of what you've just discussed, MOD lessons learned. So thank you very much. Thank you, Chair.
Thank you very much, Matt. I want to follow Matt's question there because it does seem to me that trust was one of the trust and co-design were the two things that came out for me on Monday. And it seems to me that once you start on a scheme, if you get it wrong, you start to lose that trust, you're always playing catch up. So would anybody disagree that in designing a new scheme, you should actually incorporate at the beginning what the outreach programme is? I mean, both David and Gareth have discussed quite in detail what their outreach in their two schemes are. Does anybody disagree with that? Well, that's one of the principles we need, I think, to establish in new schemes. Can I just take one point up with you, Jeremy, which you mentioned, I think. This outreach firm that you employed. Now, Fighting with Pride wrote to us to say that you employed this new agency at a cost of £60,000, 16 months after the scheme had started and 6 months before it was due to finish. They basically said it was too late. Again, isn't this an example of something that should have been done at the beginning of the scheme rather than two-thirds of the way through?
This was not the only form of outreach. This additional intervention has been specifically agreed in order to provide an additional level of outreach and, if you like, awareness raising for the scheme in its final period, essentially in its final 6 months. And I think we're all worried, and I hear it from the committee, we're all worried about whether or not we will have received the applications by the closing date. The department looked at that problem, was trying to get ahead of that problem with this additional support. We've already provided grants to Fighting with Pride and Royal British Legion for a much longer duration of the scheme. we've worked closely with veterans groups, local authorities, NHS, regimental associations. One of the things that we want to do with this additional level of support is to ensure that we continue, though, to reach out to those that don't have another link with defence. And that's one of the additional things that we've already been doing that, but this is additional investment because we are trying to give everyone the opportunity to apply, because this scheme is time limited for the reasons that we've talked about.
So, as yours is the most recent scheme, what lessons did you take from the previous schemes, maybe principally the Horizon scheme, and incorporated in your scheme?
Yeah, the team involved did engage closely with other schemes. I think we would say we probably learned most from the Windrush scheme, if just give you share our experience. We learnt a lot about caseworking, processing. Very concrete example of something that we learnt was the importance to think about the implications for someone's benefits up front, and the payments are exempt from means-tested benefits as a result of that. So concrete direct engagement feeding through into the sort of the policies of the scheme. There is a group as well, and Kat or Carl may want to be a better place to talk about it, where it brings together the expertise in government. And again, it's always one of these choices about the balance of expertise you hold centrally versus in a line department. But actually, this sort of matrix model can be very effective.
We're going to come on to that issue of where this all sits in government. I just want to ask you, David, you are unique from the other schemes in that you are your own delivery authority. Can you tell us, I mean, yours is probably the largest and most complex of all the schemes. Can you tell us the advantages and disadvantages of having this type of delivery authority structure?
Yeah, so first of all, I'll describe the things that we've learned over the 2 years that we've been in place. And I think we've learned very quickly that track record matters. So I do think it would have been really difficult for example, for the DHSC to deliver this compensation scheme. The inquiry was very clear about, what had happened, in particular the destruction of records, but also how individuals were treated by previous government organisations. And so I do think track record is really important. And for this group of people, independence was really important. The second thing is infrastructure is valuable. So in the 2 years we've been in existence, not only have we started the claims of 4,500 people and made offers of more than £2.7 billion, but we've also had to find 2 locations in Glasgow and in Newcastle. We've had to enrol a pension provider. We've had to get payroll systems for people. There's been a whole set of complications that have been alongside what we've been doing. So infrastructure does matter, and if that infrastructure had been there when we started, I think we could have gone even faster than we have gone. And the third thing I'll say is engagement with communities that have suffered so much harm is difficult, complicated, and takes effort, energy, and investment. And I think we have learned as we've gone along what that takes. And we're still learning now. So again, it's not, I would say there isn't a standard approach that people should use to this. It's something that we really have to get involved in. And we ask Ipsos Mori to survey confidence in us amongst the community. And when we started, unsurprisingly, it was incredibly low. It was 33%. We managed to build that up to 55%, which is encouraging, but there is still a long, long way to go. So those 3 things were really important, I think. I think the other thing I'd say is we are independent in the delivery of the scheme. And I think certainly when we started, there was a great deal of confusion over who was responsible for the design of the scheme and who was responsible for its delivery. And if I have a big regret, it's that we were not clear about that right at the beginning.
I'm really pleased that you surveyed your claimants. It does strike me that perhaps 55% is not a huge endorsement of your scheme in terms of satisfaction.
Well, I'd love it to be much higher. What I would say to you is that when you talk to individuals in the community and you understand what they have gone through, you will realise what a big journey it is for them to have confidence in government. You know, successive organisations that were put in place to look after them, all did great harm to them. And therefore, anything that looks political, government, parliament is going to be very difficult for them. So I want that to be higher. We're working really hard to make it much higher, but those are incredible strides to have made in 2 years.
Yes, I accept that. I think, as with a lot of things that this committee looks at, it was gripped too late. Had it been gripped much sooner, I mean, here we are, you know, people going back to the 70s. It's a long time people have waited for justice.
Entirely agree, and that is part of the complication of this scheme. Is you've got quite complicated regulations to recognise the different circumstances that people are in. The tiers and tariff scheme makes it possible to allocate people to those relatively quickly. So our cycle time when we start claims is less than 40 days, for example, on average. But you've also got incredibly complicated circumstances because the harms that were done to people were done in very many different ways by very many different organisations all across the United Kingdom and over decades and decades ago. And that makes for a very complicated picture.
So, final question for you at the moment. I'm not in any way criticising you or your organisation. You came to this, you were given the job. I assume that because of the complexity of it and people now claiming from states, from people who've sadly died, that you will be there for a long time.
Our aim is to do this as quickly as possible. It was interesting hearing you talk about deadlines. So in the regulation set out for the infected blood compensation scheme, the deadline for applications is the 31st of March 2031. My ambition is that we will have completed the claims that we have in front of us a long time before that. And I do think we also have a job to do about awareness raising, particularly in communities that are hard to reach. But our primary focus at the moment is the 19,000 registrations that for claims at the moment, that people are in front of us and making sure that they get paid as quickly as possible.
Very good, thank you. Rachel, please.
Thank you. Just before I ask my question, can I say that I was very pleased to hear you mention the capture scheme, and I'd be grateful if I could have a word with you at the end of this meeting because I have a constituent who's been very badly affected. So we've kind of touched on this, Chairman, about these different schemes. And obviously you have some learnings from each. But can you ask me, it's not a difficult question, why does government still lack a sort of permanent central body to oversee and advise how compensation schemes are established and administered? And is there thought of there being one in the future?
Yeah, it's a really important question, and it obviously was raised as part of your 2024 report, and since then a huge amount of work has gone on to share best practice, which I hope you've heard a lot of the benefits of that. Certainly there are huge merits in having a single place where you can administer compensation. There are huge efficiency gains. You can set up IT, you can provide that arm's length independence in a consistent way. There are also challenges to doing it because I think we come back to trust as one of the most important things. We have a wide variety of different people who've been impacted in lots of different ways, and I think inevitably you would come across instances where a single organisation couldn't either legally or practically build that sort of response that's bespoke, tailored, and appropriate for the sort of communities and victims that we're dealing with. So we looked at this again when we set up the Infected Blood Compensation Authority, and we concluded it was so bespoke, complex, and for applicants going through this, we wanted to take a very, very tailored approach. Now, there are lots of things that we've invested in and quite a lot of money that we've invested in, which I hope are of constant value to government forevermore. You asked about how long the Compensation Authority will be alive. Well, ultimately, the assets, the intellectual property, the IT, I hope we can transfer and use and deploy more broadly across government. But I sort of think that, one body covering the tens of different schemes that we're talking about with the huge levels of variation involved, I think I'd need to be persuaded that the outcomes that would deliver outweigh the benefits of having bespoke and very tailored arrangements. It's something we should constantly come back to.
I'm very, very pleased to hear that you recognise the importance of having very tailored systems, infrastructure and skills to deal with the unfortunate victims of whatever scheme you're dealing with.
I think there are two aspects to Rachel's question. There's the design of the scheme in the first place, and then there's the implementation of it. Now, whether one organisation can do both those, because basically what one needs to do, which is why I was very careful with my question to Jeremy, learn the lessons that went wrong on previous schemes. And I just think that Rachel is right. There needs to be somewhere in government where there is a sort of permanent presence, if you like, that is learning the lessons from what went wrong in previous schemes.
And naturally, that is the Cabinet Office, that we are the natural home for these sort of cross-cutting policy matters. Obviously, for large schemes such as Horizon, you've also had working groups set up periodically. The reason why the Cabinet Office has done so much in this space is because we're also looking at inquiries, the Public Accountability Bill. And I think one of the most important policy questions of our day is how do we get fast truth and reconciliation to people who've suffered injustice at the hands of the state. And we are looking at the policies around inquiries, about how we change the culture in the state to recognise performance issues faster, better, more openly, more transparently, because that redress, that pace of truth and reconciliation should, if we can improve it, and we will strain every sinew we can to try and improve it, that should prevent the need for these very expensive compensation schemes in generations to come. But this is really hard work to learn some of the lessons here. You know, time and time again, inquiries come up with very, very similar recommendations about culture, guidance, ways of working, what's actually driven state failure. And time again, we put in place more controls, more different ways of working. So having great people at the centre of government trying to answer these knotty problems is one part of it. Having a state that puts these sorts of lessons learned at the heart of how we operate every single day in our culture and our leadership is another one.
The best will in the world, and we've heard from Sarah earlier at the top of the session, there will be things that go wrong in government. There will be a need for compensation schemes, and therefore we've got to be thinking about how we do it in future. Now, I wonder if you could just answer for me. I'm a little bit confused. On the one hand, the NAO tell us that the Cabinet Office reviews alternative arrangements, including structural arrangements that would allow compensations to begin and operate in a more timely, efficient and effective manner. On the other hand, we're told by the NAO, DBT is chairing a ministerial group to consider options for improving future delivery of redress and explore the feasibility of an independent body. It seems to me that there's possible overlap and confusion there.
Well, I think this is modern government in that obviously the Cabinet Office is the convening, coordinating, cross-cutting centre of government, but quite often we ask our line departments, and in this case DBT, given its extensive experience with Horizon, to lead on certain matters. And I've come to this committee many times before to talk about the struggles of how you get departments to work together. I actually think this is a very good example of open engagement. If the Cabinet Office did everything that was cross-cutting, we'd be an even bigger, larger, more complicated department than we are today.
And obviously we work very closely together. The Cabinet Office started by chairing the Cross Whitehall group. DBT is currently chairing it. We have a recommendation from Sir Wyn Williams in this area. He felt that there was merit in setting up an independent body in the future, so DBT has been doing some of the running on it. I would say that Sir Wyn also said that to move whilst the scheme was up and running could potentially delay things, at least that's how I interpret it. I would also say, while I've got the floor, that I think it's worth being aware that whatever structure we set up, some of the claimants will be unhappy with the offers that they are given and therefore will criticise that body. So a structural solution takes time and investment, and it doesn't necessarily lead to a very different outcome.
question. I mean, I don't think anybody's suggesting that we wanted to set up a body that altered the whole thing part way through a scheme. These schemes have got to take their course now, and I think the victims would expect that. Sarah?
I was just going to follow up and ask, in the here and now, we have the five of you in front of us who are working and collaborating, but would an independent body not be a repository of institutional memory in a way that what you're currently describing is not?
Your point about having corporate memory, I'm not sure. You're sort of implying that should be independent. I think that is part of the huge value of the work that the NEA have done for us, is to critique our corporate memory and how we've gone about learning the lessons. So my sort of personal sense on this is that it's our job as leaders and as big departments of state to make sure that we are sharing that corporate knowledge, retaining it, sharing it, and recording it for posterity. And that is what we are. That is what we are doing.
Thank you, Chair.
Happy? Rupert, please.
Thank you, Chairman. Yes, I'd just like to thank, as usual, Gareth and his team, because this is a fascinating document you put together. There's some great data in there, particularly for things like on page 18, figure 3. But I don't really want to go into the detail, because I actually think this is about getting the principle right now, not necessarily looking at all the detail and the failures of the past. And I'm struck when I read a document like this about effectively the people who've suffered as a result of bad government decisions. And none of you are to blame for the bad government decisions. You're trying to clear up the mess that bad decision making has created. And I wasn't here on Monday because I was at a rape gang debate in Westminster Hall from an e-petition which I'd moved. That's going to be the next compensation scheme you all need to prepare yourselves for, and I'm going to mention another one in a minute. But I just want to read 3 things which I read from that meeting. Sir Alan Bates, speaking on the Horizon scheme, said, "I think there's a fundamental problem within all these schemes, and that is government should not be involved with them. The civil service just grinds them into the ground." We then had the Reverend Clive Foster speaking on the Windrush scheme. "I think having the people who were affected the most in the room to be part of that decision is really critical." And the third thing I thought was key was Kate Burt, speaking on the infected blood scheme. She said an independent body is absolutely critical, and not constantly having to reinvent compensation schemes and not have them attached to the department which has done the most harm. So I think there's a lot of wisdom in that meeting. I think we collectively, this is government, and I include myself in this, need to think long and hard, as I say, about the grooming gang scandal, which is going to end up with compensation payments, particularly from the care homes where girls were being abused from. But even more importantly, COVID. The worst decision-making of all came around COVID, and there's going to be some vast compensation from COVID. So I just ask you all, the other thing that strikes me is, you know, continuity is so important to solving these problems, and yet I look at all your CVs every time, particularly the permanent secretaries. You all move around, you hop around like jack-in-the-boxes. None of you stay in your departments for more than 5 minutes, and I think both you, Gareth, and you, Jeremy, you move around so much that how can you possibly all get your minds around solving the outcome of this bad decision-making if you're not there for more than 5 minutes? So I just like to know that you're not going to consign what we're discussing here to the bottom drawer for another year before you come back here, because I think you've got some massive compensation still rattling down the track. and Chairman, I think we have a duty to the public, and particularly to the taxpayer, to make sure that we actually do this time put something in place that listens to the evidence of these very intelligent people who've suffered. And as I say, I've studied the post office scheme in huge depth. And I'd like to think that as a result of today's meeting, we can actually get something that's durable and fit for purpose. And, you know, as I say, it's government's fault. You're trying to clear it up. I personally don't think the civil service should be anywhere near trying to clear it up. I think it's a government error. You're a function of government. It needs an independent body, to other questioners' point, to actually oversee this. And we need some continuity from the permanent secretaries. We don't want them moving around all the time. I think that's a terribly bad situation within the civil service. So I'd like you to tell me that you think we can get the next major compensation schemes right.
So if I may start, and there's a lot obviously in what you've just said. So if I perhaps start with your final question there, the whole point of this process is to make sure that we learn lessons. And we are determined to do so. Your point about we're here to serve justice, we're here to provide reconciliation for thousands of victims who have suffered, that is a core part of what public servants do, and we take it very, very seriously. So ultimately, it is our job to learn those lessons and to make sure that we follow through on every single lesson that we learned, and we put it in place quickly as best we can. That's also recognising that the civil service is here to oversee this system. I have a lot of sympathy for comments from community groups who don't trust the civil service because they see us as part of the institutional failures that have happened in the past, and I understand that. And I think the Infected Blood Compensation Authority is a good example of an entirely independent body. They're not civil servants, they are public officials, independent of government, undertaking the delivery of this work. So there's plenty that I recognise there, but if there's any assurance I can give to this committee is we are determined to learn those lessons, and we will be ready for any further compensation schemes that the government decides to discharge.
Thank you. I don't think I can say any more to that, Geoffrey.
I want to come back on this point, and I want to take the committee and our witnesses to page 40, paragraph 2.24, and I'm going to read that paragraph out because it's so important. The inquiry, this is the Wynne-Williams inquiry, also recommended that the government should establish a standing public body to devise, administer and deliver schemes for providing financial redress to persons harmed by the action or inaction of public levies. Reflecting a similar recommendation in our lessons learned government compensation schemes report that was asked our report. In its response, DBT acknowledged the advantages of an independent body, but noted that it was unlikely that one could be established in time to take over existing limited compensation scheme. Well, I've already asked that question. It then, that paragraph importantly goes on to say DBT is chairing a ministerial group to consider the options for improving future delivery of redress and explore the feasibility of an independent body. The government plans to make a substantive statement on the matter by summer 2026. I mean, listening to both your replies, Kat and Gareth, can I have your absolute assurance that you have an open mind on whether there should be an independent body, both, as I say, for two aspects of these schemes, both for the design and for the delivery? Because, as I say, I repeat again, what we heard on Monday, trust and co-design are the two key aspects of these schemes. We can never again have schemes like the Infected Blood scheme, with great respect, Horizon, or Windrush, or any of the other ones, Jeremy's scheme. I mean, the least we can do when something goes wrong is to put in place a body in which people have trust, which is designed so that they can operate it and it can pay out relatively quickly without being too litigious. I can't stress more than that, really.
Well, I can only assure you we have a very open mind. We approach all of this with humility. We've set out some of the merits and the challenges of having such an independent body. Our job is to advise ministers of the merits, the benefits, and ultimately for the government to decide how best to discharge the compensation schemes in practice. And it's also our job to make sure that we take on board the important evidence from victims, communities, this community, and other interest groups. So we will faithfully represent that in any decisions that are made by government off the back of your recommendations.
And I thank you all very much. And I address all those victims out there. some of the subjects we've discussed this morning are pretty dry, but of course at the back of it all there's somebody who has been damaged in some way or another, and it is those people we really should look after. So I thank you all very much. It's been an important session. Important evidence has been given to us. An uncorrected version of the transcript will be available in the next coming few days. We will, of course, as usual, produce a report with recommendations, which we hope you'll all look at very carefully. But again, you're all very busy people. To get you all in one room, I think, has been an important opportunity. Thank you very much.